My son's dinosaur lamp was sitting on the sidewalk in the rain when I got home from work, and the key that had opened our front door for 3 years no longer fit the lock. It was a Wednesday. I had picked up a double shift, and I was tired in the specific way you are tired when you have been on your feet for 10 hours, and you are still thinking about everything that needs to happen before tomorrow morning. I turned the key, and it did not turn. I turned it again. I looked at the door, and then I looked at the pile of black garbage bags and boxes stacked against the wall of the building, and I saw the lamp with the green dinosaur base that my son had picked out himself at a yard sale when he was 4 years old, and I understood what had happened before I had words for it. Everything we owned was on the sidewalk. The lock had been changed sometime that day while I was at work, and my son was at school. We were still 3 weeks from the end of the month. My last rent payment had cleared 6 days earlier. I had the bank confirmation on my phone. The rain was light but steady, the kind that soaks everything slowly. The retention anchor is this. The management company that changed those locks had done it to 4 other tenants in the same building in the previous 14 months. I did not know this yet. A woman named Diane would tell me 11 days later, sitting across a desk at the local Citizens Advice Office, and when she told me, her voice had the particular flatness of someone who has seen the same thing too many times. My name is Vanessa. My son Marcus was 7 years old. We had lived in that apartment for 3 years, the only home he had ever known, the place where he knew which floorboard creaked and where the light came in on Saturday mornings and which neighbor had the dog he liked to pet on the stairs. 3 years of ordinary life, and it was in garbage bags in the rain because a management company had decided that changing the locks was easier than following the law. I called the number on the management company's website from the sidewalk. An automated message told me their office hours were 9 to 5, Monday through Friday, and to leave a voicemail. I left a voicemail. I called again. I called a third time. Marcus was at my neighbor's apartment. She had picked him up from after-school care, as she sometimes did, and I needed to figure out where we were going to sleep before I had to explain to a 7-year-old why his bedroom was outside. We stayed at my sister's that night. Marcus asked why we were there. I told him the apartment needed some work done. He accepted this with the particular trust of a child who does not yet know that adults sometimes say things that are not true, because the true version is too much. I did not sleep. The Citizens Advice Office was on a side street downtown. I had never been inside one before. I went on a Thursday morning with a folder of documents: lease agreement, rent payment confirmations, the voicemail I had left and not received a response to, a photograph I'd taken of the pile on the sidewalk with the timestamp showing. Diane was a housing specialist, methodical, unsurprised, and possessed of the specific quality of someone who recognizes a pattern immediately and goes looking for the evidence to prove it. She asked me if I knew of other tenants in my building who had been removed. I said I did not. She pulled up a database of housing court filings in our county. She typed in the building address. She turned the screen toward me. 4 names, 4 cases, all within 14 months. All with the same management company listed as the respondent. 3 had been resolved through small claims court. 1 was still open. 4 tenants. Same company, same building, same method. Diane said, "This isn't a mistake. This is a business model." She said she was going to make some calls that were technically outside her remit, and she looked at me in a way that suggested she had made similar calls before and was comfortable with the boundary she was crossing. The midpoint was the attorney. Diane had a contact, a housing rights attorney named James, who took tenant cases on contingency, meaning he collected his fee from any award rather than from me up front. James reviewed the documentation and filed for emergency injunctive relief, a court order requiring the management company to restore my access within 48 hours. The management company's response to the emergency filing was that I had violated my lease by subletting a room without permission. I had not subletted anything. There was no subletter. There had never been a subletter. James said, "They need a reason. This is the reason they chose. Watch what happens when we ask them to produce the evidence." They could not produce the evidence because the evidence did not exist. The judge granted the injunction on a Friday afternoon. I was back in my apartment by 6 o'clock. Marcus walked through the front door and went directly to his room and started telling me about his day. And the lamp with the green dinosaur base was back on his nightstand where it had always been, and he did not ask any more questions about why we had been at his aunt's. The civil lawsuit was filed the following month. The management company settled before trial, $22,000 plus legal fees, plus a formal agreement to cease the practice with all current tenants in the building. 3 of the 4 previous tenants who had been removed had not known they had recourse. They had taken what happened as final. One of them told me later that she had assumed she must have done something wrong, that the company must have had the right to do what they did, because otherwise, why would they have done it? That assumption is the business model. That is exactly what they were counting on. I still live in that apartment. The lamp is still on Marcus's nightstand. Some nights when I check on him before I go to bed, I stand in the doorway for a moment longer than I need to and look at that lamp and think about the sidewalk and the rain. You never fully stop thinking about it. But you do get to come home.